everyone, welcome to Oregon Law Lab. It's a series where we explore why the workplace is the way it is and where we're going next. I'm Liz Tippett, a professor here at the University of Oregon Law School.
And I'm Jessica Brown, a 3L here at the University of Oregon School of Law.
Today, we're talking to Professor Lea Vandervelde, a law professor from the University of Iowa.
During this interview, she will explain to us the foundations and the origins of employment law and explain more so the framework of where we are today.
In this part one of our interview, she'll take us all the way back to the early 1800s when American employment law was heavily influenced by a British legal scholar named Blackstone. Hi!
Hi.
Professor Vandervelde, it's so great to see you.
It's so nice to meet you.
Thank you, Professor, for taking the time to speak with us. I'm particularly excited to talk with you about labor and employment law. I wanted to know what specifically about the 1800s caught your attention.
Well, many of the categories that we used originated in the 19th century, and many of them come from Blackstone. Blackstone's treatise, in terms of numbers of editions and numbers of volumes, ranks up there with the Bible and Uncle Tom's Cabin as the most popular books of the 19th century. Every lawyer whose probate I've ever looked at had a copy of Blackstone's in his personal possession.
Really?
Wow.
Now, what Blackstone meant was that Blackstone had created this organization for master and servant that was premised on slavery. His first category, his first status, was the status of the slave, where the master had all the cards and the slaves absolutely none.
Mm-hmm.
Then he built up other statuses above that. Apprentices, domestic servants who lived within your household, domestic servants who slept outside your household, hirelings, and even the higher orders of people like lawyers and bailers and bankers and stewards who were actually performing services but might have a very high status in society.
So even if you remove slavery, you still have the other structure that we inherited from Blackstone. You know, the master-servant relationship is still in the restatement of employment law today. It never left, even though it's hidden.
It is true. Without slavery, you would have expected all of these pieces of dominance and subservience to be systematically eradicated, but they weren't.
Yeah.
Some of them were, but many of them weren't.
Let's fast forward to the end of the Civil War. Congress passed the 13th Amendment, which abolished slavery and involuntary servitude. It seems like an obvious question, but how did the 13th Amendment change employment law?
Yeah, there's a huge shift before the 13th Amendment's passage and after, in terms of the focus of what the Reconstruction Congress is thinking about and talking about. Before the 13th Amendment, they're talking about compulsion. They're talking about being compelled to work and using physical violence or the courts of law or overseers to force people to work. But once the 13th Amendment is passed, the idea is to bring freedmen to a position of parity with their masters, to make sure that they have autonomy, that they have dignity, that they have mobility. So then, instead of being free from compulsion, the whole dialogue shifts to being free to a wide variety of things that individuals in the United States, citizens of the United States, should be able to do.
One of the things that I think is really interesting about your work is how the 13th Amendment raised a lot of questions for Congress that we don't really think about today. So obviously, before the Civil War, we knew what slavery was, but the 13th Amendment raised a lot of interesting questions for Congress about what does it mean to be free.
Then the planters told the freedmen that anyone who came to visit them had to have the master's permission, had to have the consent of the master. Congress reacted in such a way as to suggest this is not the kind of restriction that an employer should be able to impose on an employee.
You mentioned surveillance. That's something that we still struggle with today, as a legal matter.
and also the degree to which union organizers can enter employers' property in order to unionize, in order to organize.
That concludes part 1 of our interview with Professor Vandervelde.
And if you want to check out the next part, be sure to subscribe. We'll post it in the coming days.